It's interesting, I was looking up some statistics, and apparently even FinCEN estimates that there are some 30 million registered entities in the U.S. that will need to report
Mm-hmm.
to FinCEN before the end of this year. And apparently, the number of entities that have already reported is very, very small. So, in terms of compliance, assuming we have compliance and people do follow the rules that the law says they must, there's going to be flood, the floodgates will just open at the end of this year with all these companies jockeying to report. So the takeaway probably is you need to start thinking about this now and make sure that you understand what your obligations are if you are involved with a reporting company
Mm-hmm.
and start making arrangements.
My name is Tesh Patel, and I am an attorney with Cohen Pollock Merlin Turner, and I specialize in estates, trusts, and tax planning for high net worth individuals and try to minimize the taxes they pay along the way as they try to shepherd the wealth to the next generation.
And my name is Doug Wessinger. I'm also an attorney at Cohen Pollock, also working in the estate planning area, primarily with a focus on estate tax issues, estate tax, gift tax, fiduciary income tax issues. Also, a lot of work dealing with IRS employees and generally trying to make our clients have a lower tax liability than they might otherwise have if we weren't involved. We're going to talk a little bit about the Corporate Transparency Act, which I believe was part of a giant federal legislative package that was passed in 2023. It's just sort of a small piece of a much larger piece of legislation, but it has a big impact on a lot of our clients who are small business owners. The law went into effect January the 1st of this year, and it essentially requires a large population of business owners to start making very detailed informational items available to the federal government, to federal law enforcement officials. So there's a little bit of a controversy about the law in the first place. It's something of a open question as to the applicability of it, whether it's constitutional. We'll get into that a little bit later. But for starters, I think what we're going to do, and I was going to let Tesh kind of take the lead on this, just kind of go over the general rules that apply under the Corporate Transparency Act, which we may call to make it briefer, the CTA. But it's interesting things that are developing, and if you want to just give us the overview.
So reporting companies are the ones that are subject to the CTA filing requirements. And the reporting companies that were in existence before the beginning of this year have to file their report by the end of this year. Reporting companies formed this year, they have 90 days from formation to file, and reporting companies that'll be formed next year or later are going to have 30 days to file their initial reports. And then anytime after an initial report is filed, if there's any changes to the report, you have 30 days to file an updated report. And then we sort of get into what is a reporting company, which entities are actually subject to the CTA. All right, that's a pretty broad term, and it's pretty much any entity that has to be that requires a filing with the Secretary of State or a similar office. So sole proprietorships are exempt, general partnerships are exempt. If you form a trust in Georgia. You don't have to register it with the Secretary of State or any sort of office. It's a private entity. It doesn't need to actually file a report itself. But single member LLCs certainly are required to file a CTA, beneficial ownership report. So there's a long list of specific entities that are not required to file beneficial ownership reports, and I would say that entities that they consider are larger companies, ones that have, based on income tax returns, more than 5 million of gross revenue and 20 employees, which may exclude a number of them out there, but there are a number that are small companies that
Right.
will
I
certainly.
mean, it's really targeted for, quote, small business owners.
That's right. That's right. The reason for that is because the larger ones are going to be subject to other requirements.
Other federal regulation.
Correct. So they're the owners of those entities that are going to be known through other means. And then you get into, well, who is a beneficial owner? And that person is the person who's going to show up on the beneficial ownership reports. And it has to be an individual, so it can't be another entity or something like that. But it's anyone who either owns 25% or more of the entity, or its equity interests, or controls it, or
A
exercises.
shareholder or a partner or member, somebody that actually has a financial stake in it.
Correct. But it's also those who just exercise control over the operations of the company as well, not just.
Right. A beneficial owner can be more than just an owner.
Correct. So then I think the issue that comes up in our workspace is, well, what happens when a trust that doesn't have to file a beneficial ownership report owns more than 25% or more of the equity interests of a company that is required to file, right? And so what information do we need to provide about that trust to satisfy the CTA requirements?
Right. And if I could jump in, just sort of, typical for estate planning reasons, we'll often have a situation where someone who has had a successful small business wants to sell the business to some sort of a family trust.
Mm-hmm.
And it's often done for estate planning purposes so that the original owner would set up a trust. He would then typically sell the business to the trust, and then the trust becomes the owner of the business. The trust beneficiaries are probably the owner's children and grandchildren, but it's a very, very typical situation that's how a family business ends up inside a trust, or at least a portion of it. So the issue that we've been discussing a little bit before we got here was, well, how does that really apply in terms of who is then the beneficial owner of that trust?
Right.
Because you have to essentially look through
Mm-hmm.
to see the business itself is owned by the trust. The trust, though, is not by definition a beneficial owner, but somebody is the owner of that trust. And the rules get a little bit arcane
Mm-hmm.
in terms of who then is the owner of that trust. So you want to sort of talk about that too?
Sure. I would say that, so under the CTA, people who are considered, and this is again individuals who are considered beneficial owners, are going to be trustees and other people who have authority to dispose of the assets of that trust. Any beneficiary who is the sole recipient of income or corpus of the trust. So if you have a trust with just a sole beneficiary, that would be the current beneficiary right now. Any beneficiary who has the right to demand a distribution or withdrawal, and this is a wishy-washy term, substantially all of the assets of the trust, whatever that may mean. And it also includes the grantor, the person who set up the trust, if they have the right to revoke it, or withdraw assets from the trust.
Or substitute assets.
Correct.
And the interesting thing, though, that we were discussing a little earlier too, is in terms of the trust beneficiaries, at
Mhm.
least in the kind of practice that we have, I'd say 80% plus of our trust, the beneficiaries, because of the restrictions on their access to trust assets, would not be beneficial owners under the CTA.
That's correct. And the vast majority of trusts. But
Right.
I mean, the big takeaway with trusts for me and the CTA is you just have to look at each trust on a case by case basis and make that determination. It's just,
Right.
it's hard to say that every time someone, every time you set up an irrevocable trust for the benefit of kids and grandkids and so forth, that the kids are never going to be beneficial owners.
Right.
Right. By virtue of them being
Right.
beneficiaries.
Would you agree that a Q-tip trust would, the surviving spouse would be the beneficial owner of a Q-tip trust?
Right. Because during that surviving spouse's overlife, she or he is the sole permissible beneficiary of income.
Right. So that's one kind of trust where it would apply, but in most trusts, I think we agree that it probably doesn't, which is a little bit of an irony that what we consider beneficial ownership in a legal sense
Right.
is not the same as beneficial ownership for the
CTA.
CTA.
There are a couple of exclusions that are worth noting, okay? And this will take me through the short summary of the CTA. So a beneficial owner can't be a minor child if the information of the parent or guardian of that minor child is already reported on the beneficial ownership report as well, okay? And if someone is simply acting as custodial agent or a power of attorney or intermediary or something like that, then that person, simply by acting as that agent, doesn't report himself or herself individually. Instead, it's the principal that they're acting on behalf of. If you're an employee of an entity, if it's an individual that's acting solely as an employee of an entity, and that employee's control over the economic benefits from that entity is simply from that employment status, then you don't have to file. And then any person whose interest is in a company or a reporting company is solely by virtue of a right of inheritance, right? This would be transfer on death designations, beneficiary designations, and so forth. Just because you're listed as a beneficiary right now doesn't mean that you are a beneficial owner, because you won't actually receive that interest in the company until after the death of the current owner.
And of course, again, all of these individuals who are identified as beneficial owners, all this personal information has to go to the FinCEN, which I think, what does that stand for? Financial Center for Crime Enforcement.
Yeah, I think
Well, anyway, it's a Treasury Department division, and it's basically the one that is charged with rooting out money laundering and federal, bank fraud and whatever.
That's right.
So they have some pretty strong powers. And so, this information does go into the database.
That's right.
And I'm assuming it stays in the database. So if you're a beneficial owner, there you go. It's interesting, I was looking up some statistics, and apparently even FinCEN estimates that there are some 30 million registered entities in the U.S. that will need to report to FinCEN before the end of this year. And apparently the number of entities that have already reported is very, very small. So, in terms of compliance, assuming we have compliance and people do follow the rules that the law says they must, there's going to be a floodgates will just open at the end of this year with all these companies jockeying to report. So the takeaway probably is you need to start thinking about this now and make sure that you understand what your obligations are if you are involved with a reporting company, and start making arrangements to get this information in by the end of the year. The penalties are
they're pretty harsh.
They're fairly punitive.
They're $500 each day, and can maximum rise up all the way to $10,000 or 2 years
per entity. I'm assuming.
Correct. 2 years per report. And up to 2 years of imprisonment. you know.
That's right. That's another consideration, I guess.
There's obviously a safe harbor in case there's incorrect information that's out there. If it's corrected and there wasn't actual knowledge that the original report was inaccurate. So if there's just some, unintentional errors that occur, yeah, you have a safe harbor period within which to
Right.
correct it. But
But yeah, it can get severe if the non-compliance is intentional.
going back a little bit to your point about how, to this point, not many entities have filed reports. I will say, though, at the beginning of this year, when clients asked me whether they needed to file this report or not, I told them to sort of hold off because there was a case that was sort of making its way through the
True.
appeals. And I think you've done a little bit
And
more
it is an 11th Circuit case, so it
Correct.
would affect us.
out of Alabama, but yeah. So do you want to talk a little bit more about sort of where we are in that process, what the argument the government made was for it, and what we were kind of discussing earlier?
Can, but I wanted to talk just a little bit first, if I could, about the reporting requirements. This was sort of an interesting twist on all this about discontinued entities.
Yeah.
Just because it's, I don't know if we mentioned this, you probably did, but even if you have a single member LLC, like a lot of professional people would have, independent contractors often will just have a single member LLC, you still have to report that, even though your single member LLC is disregarded for tax purposes, for income tax purposes. It's not here. I mean, it is a reporting company. And so the net is pretty broad in terms of who has to report. And the interesting twist was if you had let's say an LLC, just because that's what most people have now. You have an LLC that was formed before 2024, and that LLC was also formally dissolved. It's run its course, and you file papers with the Secretary of State to formally show dissolution. You don't have to file because that's basically a dead company at that point. Interestingly, though, if you had a company that was formed before 2024, and instead of filing formal documents with the Secretary of State to dissolve the company, you decide that you want to do what some practitioners used to call the poor man's dissolution in Georgia, which just means you don't go back and file any additional papers with the state of Georgia. But if you don't file your annual registration for some period of time, the entity is administratively dissolved under Georgia
Die
law.
on the vine.
Right, and that's what people typically do. If that's the route that you take, guess what? You still have to keep reporting each year that you have some changes. Well, maybe you don't have any changes if it's administratively dissolved, but at least you are still subject to reporting requirements under the CTA. And the interesting example that we were talking about a little bit earlier was, well, what do you do if you form up an entity in 2024, let's say in January, and then before the end of the year, you've run your course, you've done what it was intended to do, and you dissolve the entity. My reading of what the rules say is you still have to file the reporting information for the formation of that entity, even if it is no longer in existence. And we may have a difference of opinion here about that 90 days.
Yeah.
But let's say it's more than 90 days when it's dissolved. You still have to report the formation. We agree with that, right?
Correct. If on the day that the report is due or filed, it is still in existence and hasn't been formally dissolved this year, and it was formed this year, I'm of the opinion that you still have to file the report. It's in existence. But if you dissolve it entirely within the time period that you're required,
before your reporting date has actually come about.
Correct. I'm not sure how you can file that report because there are no beneficial owners at that time to report. The entity no longer exists. So mechanically, you just couldn't do it. You
I'm
know,
not sure if the feds care.
I understand that, but I guess in that case, it would be required. You would be filing a report for an entity
That you don't really,
identifying
that you don't
people
really
that are no
represent.
longer
Right.
correct. Then in that case, you've misrepresented.
Right.
These people are no longer beneficial owners.
Right,
And
and I agree with that. It's sort
I
of
think-
illogical,
correct.
but it also sort of highlights the fact that the law has not been thoroughly, worked out
Yeah.
yet. There's still a lot of things that are open questions as to when it's going to apply. And the interesting thing I wanted to sort of talk about a little bit on this particular podcast was sort of the updates on the constitutional challenges that have been raised to this particular legislation, because it certainly has the feel of being a very intrusive type of law. There, of course, there's a lot of legislation already in place that regulates, banking laws in terms of what banks have to report and large transactions. And that's all part of the same purpose, I guess, legislative purpose of combating money laundering, and I guess there's national security issues that are allegedly involved, and just general, financial fraud.
Yep.
And that's what the feds say they're concerned about.
Yep.
On the other side, the question is, well, what about the citizens? Is there some privacy right? Is there some Fourth Amendment right? Is there, these other constitutional issues that seem to at least come into play?
Right.
We don't know, how it's all going to shake out. What we do know is there's been one federal district court decision so far that said, well, we've looked at it, we've heard the government's arguments, we've heard the plaintiffs' arguments, and we think it is unconstitutional. And I think, as I recall, they ruled that it didn't pass muster under the Commerce Clause.
That's right.
Which is typically sort of the way the analysis would go. They didn't really get into these sort of Bill of Rights issues. It was all just under the Commerce Clause jurisprudence. But in this one case out of Alabama, the government immediately appealed, as you might expect, and the case is before the 11th Circuit now.
That's right.
There was also a case that was decided in Oregon, but it really had to do more with plaintiffs trying to obtain a preliminary injunction on the enforcement of the new law, and the district court just said no. It's not. It just didn't meet the requirements for a preliminary, injunction. Pretty difficult to meet that test in most cases. There's also 4 other cases that I came upon that are still out there pending, but there's been no decision. So there's a lot of activity, especially among trade organizations, who feel they have a real stake in trying to come up with some clarity, I suppose, as to what the the obligations of a small business owner really are. But at least in the 11th Circuit case, they did have oral arguments. In that case, I think it was maybe September 28th. It was toward the end of September, and the commentary that I've been looking at, it seemed to suggest that maybe the 11th Circuit was probably tending to go on the government side, just because typically in a Commerce Clause type case, the government usually wins. That's just the way it is.
It's broad, right?
Yeah, there's been very few cases where where a court has decided that no, Congress went too far.
Right.
In this instance. The interesting thing, though, I thought in the oral arguments that I was reviewing, is the argument of the government in terms of the applicability of the Commerce Clause was that essentially, the triggering act here is simply the formation
Correct.
of your entity. You just form up an LLC or you form up a corporation, probably going to be an S corporation, and that's all. That's all it requires.
Hmm.
The government apparently argued that the mere formation of that entity was an inherently commercial activity. I can see the argument, I suppose, because generally speaking, that's what people would do. They're going to be conducting a business. They're going to be trying to earn a profit through whatever the activities within that entity are. But as you and I know, in our estate planning world, there are a lot of other reasons for forming up LLCs, which are totally legitimate. One of which, the big area that I can think of is in real estate ownership.
Hmm.
And as we've talked about before, very common that we'll advise our clients if you, let's say, are a Georgia resident and you have, let's say, you have a mountain property out in Colorado, with a ski lodge or something. If you got property in North Carolina, a mountain house, you should put that real estate in some sort of an arrangement like an LLC, because otherwise you'll have to go into probate
You'll have to
in
get.
those particular states
Mhm.
simply to be able to transfer that real estate to whomever you wanted it to go. So, typical estate planning advice: if you have out of state real estate, don't own it outright. Have it in some kind of an entity like an LLC. And we do it all the time. Same thing with if you had a vacation home. Let's say you're a Georgia resident, you own a vacation home on St. Simon's or on the coast somewhere. You go there on occasion to enjoy that property, but you're not there all the time. For liability purposes, we would say, well, it would make a lot of sense just to put that property in an LLC, just to limit your exposure.
Yeah.
If somebody decides to, sleep on your front porch and fall down the stairs the next morning. So that's a reason. Uh, and then otherwise, I also know on occasion is simply a matter of, guess what? Privacy.
Right.
Some people simply don't want the public record to show who the owner of certain property is. I know, well, like in the world of celebrities or in the world of even politicians,
Hmm.
a lot of times they would prefer that the general public not really know, where they live, where they are, where they stay. So it's very typical that if you're someone who has privacy concerns, which are totally legitimate,
Hmm.
you would want to have that property in something like an LLC. So it seems to me that it's a little uh, unreasonable to take the position that the formation of just the mere formation of an LLC or a corporation is somehow inherently commercial, which would then bring it within the scope of applying the Commerce Clause. But that's not my call. So we'll see, what the courts will say. But it's an interesting question.
Now, I agree with you. A couple of things that I would add are that I think the law will eventually pass muster, so to speak. I think the 11th Circuit, I agree with you, is going to side with the government in this case. But I guess what may come down in the near future is that someone on behalf of the president, the president-elect, may say, hey, we're just simply not going to enforce this law.
That's true. And
That's a
in fact,
possibility,
yeah, and in fact,
but I wouldn't rely on it.
right. In fact, FinCEN has sort of made a point of trying to reassure the public that, there's been no information disseminated to other federal law enforcement agencies to date.
Hmm.
So anybody that has sent the information in, it's sitting in a database, but it hasn't actually been disseminated out in any sort of a way that I guess it would be intended to be at some point. And I know too, they have indicated that they're sort of going to phase it in
Mm-hmm.
so that, at some point they're even talking about, the sort of the customer, who's the customer here for this database information. It's going to originally just be probably Treasury Department
Yeah.
enforcement groups, and sort of keep it within that ambit. It's then going to expand as the program, I guess, is fleshed out more to, let's say, general federal law enforcement,
Department
FBI,
of Justice.
and then state and local authorities. Then it's going to go to some other areas, and then I think finally there's a plan to make it available to financial institutions who are involved in that require it for due diligence
Mm-hmm.
purposes. So, and I guess it depends on your thoughts on, will the government make sure this information is not misused?
Right.
If how much do you trust them to make it right? There's some of those concerns still floating out there.
Yeah. Yeah.
Tesh.
Another vehicle for privacy, I suppose, is a revocable trust. It won't
Mhm.
give you the limited liability shield, the limitation of the exposure in case something happens on that real estate in another state if you're trying to avoid ancillary probate. But at least you may be able to accomplish the privacy through a revocable trust.
Right. And there's also the possibility, talking about trust again, because I mean, at least I've heard some theory about it, since banks are generally exempt
Mm-hmm.
from reporting to the under the Corporate Transparency Act. If you have a bank serving as a trustee,
Yeah.
it
Then you don't have
may
to worry
very
about
well be that you don't have to worry about it.
Mm-hmm.
Most people would prefer not to probably have a bank as a trustee if there was an individual or someone else who might not charge the same fees. But if privacy is an overarching concern, that would seem to be a way you could work around it.
That's right.